correspondence transactions, a very important topic to discuss. So far we learned the basics when it comes to the transfers. Yes, it was necessary for us to learn more about the basic transfers before we came to the correspondence, because the correspondence transactions will incorporate what we have learned before. Remember, we learned about separating the trust books from the business books. We learned about charging the fees. We learned about transferring. So it's very much important to know the rules around the correspondence. A very important topic. I can repeat, a very important topic. This takes place in a situation whereby one attorney in one location instructs the other attorney in another location to go and perform services on their behalf. Maybe there's a client in Durban and the client belongs to the attorney in Pretoria. So the attorney in Pretoria can instruct the attorney in Durban to go and perform the services on their behalf. Obviously, there will be some agreements about the fees who are going to be charged, about the allowances which are going to be given to the instructed attorney. In other words, the instructing attorney will instruct the other attorney. So the other attorney is called the receiving attorney, or you can call him or her the instructed attorney. So again, when it comes to that situation, there will be a relationship between the two attorneys. It means that the one who instructs now becomes the client to the one who receives, the one who has been instructed. Can you see now? Because at the end of the day, it's like now the instructed attorney is performing services for instructing attorney. So at the end of the day, the instructing attorney becomes a client to the receiving attorney. But the fact that the instructing attorney became a client to the receiving attorney, it doesn't change the relationship with the original client. Remember, the client is in Pretoria, so the instructing attorney is in Pretoria. For example, Sylvester is a client to the instructing attorney. It won't change my relationship with the instructing attorney. I will still become stay the client of the instructing attorney, but for accounting purposes, when we account for the books, we must make sure that we account the books between the instructing attorney and the receiving attorney. I think it will make sense by the time when you put it into practice, by the time when you put it in those real accounts. Okay. Remember, in the process, the instructed attorney or the receiving attorney will go and perform. And again, there will be fees charged in the process. Remember, it's a service. At the end of the day, the instructed attorney or the receiving attorney deserves or is entitled to a certain allowance or a fee. So, depending on what fees have been charged by the instructed attorney when he or she is performing, so he can claim an allowance of 1/3 of what? Of the fees charged. Remember, it cannot be more than 1/3. So if, let's say, for example, the fee charged in the process were 50,000, so the allowance to the instructed attorney will only be to a maximum of what? 1/3 of 50,000. So it cannot be more than 1/3. But this doesn't mean that it cannot be less than. It can be less than. Remember, we say it may not exceed, but it may be less than 1/3, depending on the agreement between the instructing attorney and the receiving attorney. So you need to understand that it may not be more than 1/3. And again, it doesn't mean that at all times there will always be a fee. Sometimes a fee may not be granted at all. Again, it's all about the agreement. So you need to check the agreement between the two attorneys before you can go and calculate 1/3 of the fees charged. And sometimes you can find that the instructing attorney instructed the receiving attorney to go and do some debt collection. I think we're familiar with the debt collection, whereby the attorney calls you when it comes to the debt that you owe. So at the end of the day, there is a 10% commission charged on the amount collected. So if, let's say, the instructed attorney managed to collect 100,000, the commission to him or her will be 10% of the amount collected or the capital collected. So you will see that there will be a statement which shows everything, all the amounts collected and everything like that. So the commission will be based on that. But you need to be careful, because when it comes to commission, there are some limitations when it comes to commission. So you need to check that with your local, institutes. When it comes to, your area, there are some limitations which you can go and check when it comes to commission. But standard is 10% commission is charged on the capital collected, or the amount collected. Remember, you must not forget the VAT implication. So sorry, I just wanted to say forget. I said fourth. So you must not forget the VAT implication on the fees and the commission. The same way we dealt with the fees when it comes, remember we dealt with the transfers. So the same procedures are followed, because the minute you charge the fee, there will be some VAT implications. Can you see now? So you need to make sure that you pay attention to that. Remember, the fees which you charge can come in the form of receiving instructions, issuing summonses. Obviously, you can do some correspondences, you can issue court notices. All those things are taken into consideration when it comes to the fees charged. Okay, so at the end of the day, guys, it's very much important for you to know all these basics. Please, for now, the theory is important. You will see by the time when you go and do the proper applications, this theory, this foundation, this basic knowledge will be very, very, very much important. Good luck for everything, and I hope that you do well in your studies. Thank you so much.